And welcome all the distinguished participants for today's FDP session. Before going to proceed with the main topic, let us have an understanding about the basic fundamentals of patent filing process in India. In general, patent prosecution is the process of communicating with patent office to obtain and maintain patent protection for an invention. It includes filing the application, examination, responding to objections, and making necessary amendments. Patent examination involves assessing whether the invention meets key requirements such as novelty, inventive step, industrial applicability, and the compliance with patent law. In this session, we will briefly understand the major stages of patent prosecution and examination and the role of the applicant in successfully obtaining a patent. So with this few introduction, once again, I warmly welcome all the participants for the Day 4 Faculty Development Program on Patent Prosecution and Examination Process. In the previous session, we discussed the fundamentals of patent law and the step-by-step process of filing a patent application. Today, we will move to the next critical stage, the journey of your patent application after filing, leading ultimately to grant. We will understand what is examination process, request for examination, the first examination report, responding to objections, hearings, amendments, and finally grant and publication. These intermediate stages we are going to see today in Day 4 Faculty Development Program. Let us have our session overview today. There are 5 major areas that we will cover. First, we will understand the examination process, including the request for examination and the role of the patent examiner. Second, we will discuss office actions and responses, particularly the first examination report, commonly referred to as FER. Third, we will examine the importance of hearings and arguments before the controller. Fourth, we will understand the amendments and claims and how claim scope may be refined during prosecution. Finally, we will discuss grant and publication, which represent the concluding stages of successful prosecution. The objective is to understand the entire prosecution journey in a structured and practical manner. Let us now look at the overall journey of a patent application. The prosecution process broadly be understood through 6 stages. The first stage is filing, where the patent application is submitted to the patent office. The second stage is the request for examination. Followed by that, the third stage is examination, where the examiner scrutinizes the application. Fourth stage is the first examiner response, where the applicant addresses the objection raised by the examiner. The fifth stage is the hearing, if a hearing becomes necessary under certain cases. And finally, the sixth stage is grant, followed by publication. An important timeline highlighted in this presentation is that the request for examination must be filed within 48 months of the priority or filing date as applicable. Failure to comply with the prescribed requirement can result in the application being treated as withdrawn. Therefore, patent prosecution is not merely a technical exercise. It is also a process of carefully managing statutory requirements and timelines. Let us now examine the first major stage, the examination process. The examiner scrutinizes the patent application with reference to important patentability requirements, including novelty, inventive step, and industrial applicability. The process begins with the request for examination. Request is filed within the prescribed period, after which the application is placed in the examination queue. The controller then refers the application to an appropriate patent examiner based on the technical field of the invention. The examiner conducts a prior art search and examines the application for compliance within the applicable provisions of the Patent Act and rules. After completing the examination, the examiner may identify objections or requirements. These objections are compiled and communicated to the applicant through the first examination report. Therefore, the first examination report should not be viewed simply as a rejection. It is an important communication from the patent office that identifies issues which the applicant needs to address during prosecution. The next stage is responding to examination. Now we come to one of the most important practical aspects of patent prosecution, responding to the examination report. An FER may contain several types of objections. The examiner may raise objections relating to lack of novelty or inventive step based on cited prior art. There may also be objections relating to non-patentable subject matter under following sections 3 and 4. Other objections may concern insufficient or unclear disclosure, claims that are not fairly based on the description, lack of unity of invention, claim clarity, or formal requirements. A strong first examination report response should address every objection systematically and point by point. The presentation emphasizes responding within the prescribed period, including the applicable extension provisions. The applicant should clearly distinguish the invention from the cited prior art. Where genuinely necessary, amendments may be proposed to the claims or specification. Technical evidence and appropriate legal reasoning can strengthen the response. Most important thing, every response should be properly tracked so that the application does not suffer from deemed abandonment because of missed procedural requirements. The quality of an FER response can have a major influence on the future course of the patent application. The next segment, we are going to discuss how to present your case before the controller. Sometimes written submissions alone may not resolve all the objections. When objections continue after the written response, the controller may fix a hearing before taking a final decision. The applicant is given prior notice of the hearing. During the hearing, the applicant, patent agent, or authorized representative may present oral and written submissions. The presentation notes that this may take place in person through video conferencing or through an authorized representative. The key to an effective hearing is preparation. The arguments should focus on the technical differentiation of the invention, inventive step, and a clear rebuttal of the cited prior art. Arguments should be structured, precise, and supported by appropriate evidence. Following the hearing, the written submissions incorporating the hearing outcomes are to be filed within specified period, highlighted in the presentation. Thus, a patent hearing should be treated as an opportunity to clearly explain the technical and legal position of the invention before the controller. Let us now discuss the amendments and claims. Amendments can play an important role in overcoming objections during prosecution. As highlighted in the presentation, amendments under sections 57 to 59 may narrow the claim scope, but they cannot introduce new matter beyond the original disclosure. Permitted amendments may be made by way of disclaimer, correction, or explanation, particularly when they are required to overcome objections or clarify the scope of protection. There is a fundamental principle that we should always remember. The amendment should not claim subject matter that was not in substance disclosed in the specification as originally filed. During prosecution, claims may be restricted or narrowed where necessary. The presentation also emphasized that amendments require the controllers leave and must remain fair, reasonable, and within the scope of the original disclosure. Therefore, patent drafting at the initial filing stage is extremely important. A poorly drafted original specification can significantly restrict the applicant's ability to amend their claims later. This clearly means that in the initial drafting stage itself, one has to thoroughly draft the patent specification in a fairly manner in order to avoid the objections in future. We now arrive at the final stage, grant and publication. Before grant, objections raised during the examination and where applicable during the hearing must be satisfactorily addressed. Once the controller is satisfied that the application and specification comply with the requirements of the Patents Act, the patent may proceed to grant. The patent is then granted and recorded in the Register of Patents maintained by the Patent Office. The grant is published in the official Patents Journal and the patent certificate is issued to the applicant. The presentation also highlights that the term of a patent is 20 years from the date of filing, subject to payment of the applicable renewable fees. Therefore, successful patent prosecution does not end simply with overcoming the first examination report. It culminates in a formal decision, grant, registration, and publication. Next, we are going to see about another most important area is patent opposition. There are two important stages to understand: pre-grant and post-grant opposition. Pre-grant opposition is filed under Section 25 of 1 after publication of the application, but before grant. The presentation states that it may be filed by any person and identifies grounds such as novelty, prior claiming, obviousness, and insufficiency. The controller considers the representation before deciding on grant. Post-grant opposition is governed by Section 25 of 2. It may be filed within 12 months from the publication of the grant by a person interested and subject to the prescribed requirements. The matter is considered through an opposition board constituted by the controller, and the controller takes the decision based on the applicable process and recommendation. Understanding opposition is important because patent prosecution may involve not only interaction between the applicant and the patent office, but also challenges from third parties. Let us now summarize the important learning outcomes from today's session. First, we have understood the complete prosecution journey, beginning with the request for examination and progressing towards grant. Second, we have examined how to respond effectively to the first examination report within the applicable statutory timelines. Third, we have discussed the importance of preparing strong evidence-based responses to examiner objections. Fourth, we have understood the distinction between pre-grant and post-grant opposition. Fifth, we have highlighted important issues relating to timelines, amendments, and claim scope. Finally, effective patent prosecution requires not only knowledge of patent law but also technical understanding, careful drafting, strategic claim management, and disciplined compliance with the procedural requirements. The practical lesson is very simple. Filing a patent application is only the beginning. Effective prosecution is what converts a filed application into enforceable intellectual property. So, with this few message, we come to the conclusion of day 4 of our faculty development program. I hope today's session has provided you with a clear understanding of the patent prosecution and examination process, including examination, FER responses, hearings, amendments, opposition, grant, and publication. This session is particularly relevant for faculty members, research scholars, industry professionals, innovators and IPR cell members, students, and startup founders. I encourage you to reflect on the concepts discussed today and apply them to practical patent prosecution situations. Thank you very much for your active participation. I wish you all continued success in protecting ideas, promoting innovation, and building a strong intellectual property culture. Thank you all. We will meet again in the Day 5 Faculty Development Program by tomorrow.